Hello, John McConnin. Just pointing out another interesting development we're seeing more and more is that now, in addition to the approval letter, we saw a waiver on a previous document, and now we're seeing a release. And this is interesting. This release is made this June 15th, 2012 by the undersigned with respect to the following note made by the borrower. And in consideration of the agreement of RFC Master Servicing, the note holder, to renew, extend, renegotiate, compromise, settle, or otherwise modify the note, or to fully, partially release borrower from the note. What does fully, partially mean? Borrowers have, borrower, on behalf of borrower and borrower's heirs, executors, administrators, successors, and assigns, collectively releasing, hereby releases, acquits, and forever discharges the note holder, RFC Master Servicing, PHH Real Estate Services, and their respective officers, etc., and all entities in privity with them. So that could mean any other, I suppose, investors, who are probably really the investors, from any and all claims or causes of action of any kind whatsoever under the law in equity that borrower and or releasing party has or may have, whether known or unknown, now existing, arising hereafter, directly, indirectly, remotely attributed to the or related to the note. This release is intended and understood to release all present and future claims of any kind that borrower and the releasing parties have or may have against the released parties. And we don't even know who's in privity with these guys. In fact, I just commented on this. I'm going to add more things to my comment to my realtor before we bring this up with the sellers. I almost wonder, this is too much, really. You're getting my impression of this note now. Can we work around this? Can we go back and say no? We're not going to sign this without letting the parties be disclosed. What other causes of action may be out there? I mean, I know from another borrower in a situation where there was a robo signing, the bank claims they might be offering them $20,000. So would this? I suppose this is releasing them from a robo signing, and yet they didn't thoroughly release this person in writing from the remaining loan balance. They discharged the mortgage, which in California we don't even have a mortgage. So I think I'm going to need to speak with these clients. I mean, this is a short sale we like to do, but I'm not so sure how you can do that without getting a better release, a better understanding of what's actually being released. So, John McConnin, just showing you the issues, not saying you always have the answers. I think you need to talk with an attorney about the risks and reward, the benefits and the risks of working on a cobbled together, as can be seen probably by the borrower on. There's no space there, and we've got partially released, fully, partially. I mean, this is garbage put together by some probably non-lawyers over at either this Master Servicing Agreement place or PHH. And someday, if there's litigation over credit, if there's litigation over class action suits, if there's litigation, I don't know, with another servicing entity, maybe even another lender who's in privity. What the heck does this mean? I don't know. We got to explore this more. But we also know that PHH is a pain in the neck to deal with. John McConnin, underwaterrealestate.com and upsidedownrealestate.com. Thanks.